All right, everybody, we're going to get started here with our second panel. If everyone can please take a seat. Our second panel is Networks as Subject and Medium of Antitrust Enforcement. And we have an all-star lineup. I'm very excited by this group. Our first is going to be Elvira Aliende Rodriguez, who is an antitrust and fintech partner. We haven't had a lot of fintech here. This is great. At Shearman and Sterling, where she focuses on EU and Spanish competition law, including mergers and cartel enforcement. She has deep experience with the European courts and regulators. Following her, we'll get Elias Deutscher. Apologies. He was an associate professor at, if Matt is not good at pronunciation, I am 1,000 times worse, so I'm going to do my best here. Is an associate professor at competition law and intellectual property at the University of East Anglia School of Law. His expertise includes competition law, interplay between competition law and IP, and European Union law. He holds a PhD from the European University Institute and was a visiting scholar at the New York University School of Law. Then we will have, and I'm going to do my best here, we tried beforehand and it was awful. So here we go. Anna Tzanaki. Tzanaki.
Yes.
All right.
Perfect.
Is an associate law professor at Lund University who is an expert in competition law, corporate law, law and economics, and EU law. She has a PhD from the University College London and was a visiting research fellow at Harvard Law School. And if we have time, my colleague and friend Matt Jennejohn will go last. We actually started at the exact same time at the law school, and he's gone on to great and wonderful things, and I'm just doing my best here. He is an expert on mergers and acquisitions, technology alliances, contract theory, and corporate governance. Before joining the academy, he was a lawyer in New York and served as a law clerk at the Delaware Court of Chancery and was also a visiting scholar at Columbia Law School. And with that, Elvira, the floor is yours.
Absolutely. Thank you, Aaron. And thank you very much, Matt. Delighted to be here. I think such an interesting topic and distinguished speakers. So I'll try to be very precise. I'm not one of the academics, so I haven't looked at all the topics I'm telling you things about today in an academic way, but I'm going to give you a bit the private practitioner kind of things that matter, and then hopefully pose some interesting questions that you guys can respond either today or in your future work, because there's certainly a lot going on. So what I thought I'll do is so obviously the topic is networks, and cartels have a ton to do with networks. It's networks of companies doing things that they shouldn't. And so that's my area of expertise. I thought I'll take a few minutes to just reflect about what's been going on at the European side on cartel enforcement, and the links obviously with what's new has a ton to do with how the Commission is looking at the market, given the decay they have had in leniency applications and the fact that the cartel enforcement is a little bit down. And that's also the case for the US, but I'm going to talk mainly about the EU. And then finalize with a few points on another issue, which is related to cartel, or at least horizontal cooperation, and which is hot on the table in the US, which is interlocking directorates, but not so much in Europe, or at least until now. So I think without more to say, as I was saying, so the most, I think, flagrant feature of cartel enforcement in the EU in the last year, but also, I think, a couple of years, has been the decay in leniency applications. And the Commission has tried to, I think, play the numbers a little bit to say that actually lately they've restarted to do down rates, and that the leniency applications are actually up, but they're comparing them to 2020 and 2021, which were pandemic years, and in which obviously there weren't very many leniency applications. So the truth of the matter, if we do look at the numbers, is that leniency applications have fallen from an average of around 40, 50 during the years of 2010 until 2016, 18. Whereas now we're seeing leniency applications that are as few as a dozen per year. So that's a drastic decay. And the Commission, I think I understand want to be making a policy point that they are still enforcing cartel. They are very, very serious about cartel enforcement. But the reality of the matter is that there is an issue here. So if we look back at what the issue is from a private practitioner, it's quite clear that the directive, the 2014 directive that introduced the private damages in Europe has had a major impact. And obviously, this took a few years to pick up. But definitely for the last few years, we have seen major private damages cases spanning all over Europe, which obviously have a very deterrent effect on potential leniency applications. And so when I advise companies, and this is, happens very, very often, I no longer can tell them, it is the right thing to just assess that if you're the first one, and this is obviously, as we all know, game theory, if you're the first one, you're not going to have any fine from the Commission and you're going to be okay. Obviously, now, if you put in that formula, the fact that you're going to face very high fines from private damages, everything changes. So if that is the start point now, basically, what is the Commission doing? And so we have been seeing the Commission being quite proactive and saying, we're putting together all the efforts in the world to try and make this enforcement, reactivate. And so a few of the things that they have doing are very interesting. Some of them, I think, have had not so much, I don't think so many people have heard about them unless you're a little bit in the world, as I am, which is really cartel enforcement. And so one of the things that not so many people know is that in 2016, so that's quite a while ago, the Commission started a new unit, which is called the Intelligence Unit, which basically all that it does is screening markets and trying to identify and use methods that are based purely on data and that are supposed to be detecting some trends that show that some of the markets may have suffered from cartel enforcement. So this is very interesting. They say now that they have had around 30 cases for the last few years in which these screening methods have one way or the other had an impact. In current cases, if it's not completely critical or they haven't identified cartel cases, they have in some cases, the minority, but in others have also been helpful to identify things that make the case stronger. So they're basically quite focused on these. There's not a lot out in there. These are some statistics and things that you can read, but the Commission obviously is not saying, at least at the moment, this case we found out with our unit. They may say it's an ex officio, but obviously then to know whether this was through a complaint or through just their screening methods or anything else, then it's difficult to understand. And I think that's a very important thing. Given how enforcement is going, that's one of the things that is going to be key. And one of the thoughts that I said when I want you guys to think about this is my question on this is, is the Commission doing this the right way? Have they approached it in a way in which, are they more focusing on structural? Are they more focusing on what is the behavioral part? And they say it's a combination of both. When reading what the member states are doing, they are also using these screening techniques. But what they are saying is in most of the countries, and I think there's a ton of member states that are focusing on, for example, bid rigging in public procurement. That's like a big part these days. And in that, apparently the screening methods actually work quite well because it's quite easy. There's not so many companies that are involved in public tenders, and then you can kind of monitor it in a more efficient way. Whereas I think in other types of industries where bid rigging is not there, then it's not so easy. So I think those are interesting things. I mean, the other thing the Commission has been doing, which is interesting, is they've introduced this whistleblower program, which basically just gives assurances to employees in companies that they can actually tell the Commission about some things that are going on in their company, being absolutely, certain that there's not going to be possibly for the company a way to identify who they are. So the anonymization part has been very novel in this new whistleblower system. I mean, the Commission has been saying that they had some positive results from there. I don't think they have ever announced or said that they got a new hotel thanks to this program, but they have put it in there just to say that this is yet another thing that they are doing to counter this decay in leniency applications, which means, less strong enforcement for cartels. So I think those are the main things going on in terms of, if you think about what the Commission has been doing. I mean, there's certainly quite a ton of new things that are going on. So, for example, the Commission, just as the US actually also put on the table this year a new, as they call, frequently asked questions on leniency, and so did actually the US. And I just want to make a point here because it's also something not so many people have perhaps stopped to think about. So in the new frequently asked questions, the Commission basically says that, we're going to try and make it easier for companies to come talk to us. So there's some anonymity that is, if you want, more strengthened. There's also a dedicated one official that is going to be put up there so that companies can refer to him or her and then make the process more smooth. But one of the things that they haven't said anything about is the timing. When in order to benefit from leniency, for leniency discount or immunity in Europe, you don't have to show that you have been very quick to go to the Commission in comparison with where you found your infringement, whereas the new guidelines in the US, and this is a major thing, they now say that in order to qualify and to get a discount, you have to actually do it in a very timely manner. So question here, will the Commission be following or will this change? I think probably we've had the 5 minutes on what's new, and we want to have a few words on interlocking directorates now. I think that would be good. So this is not an area in which there has been a lot of change in Europe. So in other words, and perhaps let's take a step back because interlocking directorates is perhaps not understood by everybody. So interlocking directorates is where different companies have one or more members of their boards in common. And this is not to be confused with what Anna will be talking about later, which is the situation of common ownership and how does that affect cooperation between different companies. So if you want, the typical example of common ownership is the two companies that are owned by the same parent company. And then obviously in that, there's all the rules that say, well, if they're owned by the same one, then there's not a problem. But what happens is that if there is a joint venture and all those scenarios, here we're not there. The ownership can be totally separate, but it just so happens that the boards have some people that are the same. So we have all heard that the CEO of Google resigned, for example, from Apple in 2009. This is the kind of situation, do we have people that are competitors or not, maybe in the future, and do we want to have the same people in those boards? So in essence, the Commission has really not focused on this very much. There's no rules, unlike in the US. So the US has Section 8 of the Clayton Act, which actually addresses and forbids common ownership in directorates. In Europe, this is not the case. So we have a ton of rules and cases on common ownership and how, coordination, collaboration between different companies may impact or may get to a situation of collusion and anti-competitive conduct. We don't have anything for the interlocking directorate. So the question is put on the table, do we need to? And so a few things that are worth looking at is that I think when you think about it and you look at the European rules, I think the answer, and I am convinced of that, just as with common ownership, I think we do have the rules in place to tackle this. So if there is a way of showing that potentially somebody having the same person in the board of two companies may give the situation where there is collusion giving to anti-competitive conduct, I think the Commission should be able to tackle now. But why has the Commission not done it? And so I always think it cannot be so straightforward. Otherwise, we would have probably gotten there already. And I think the answer is because obviously it is difficult. It's not straight away to think about the when and the how you're going to prove that this is a problem is certainly not easy. And I think that is why the Commission has just said, well, we're going to take an approach that is not just prohibited, and we're just going to let the situations arising, which if people think that there is an issue, then we will look at it. And that is something that now perhaps the Commission may be taking a look at. So it's worth just exploring, I think, whether there is need for, I don't know, more papers to be put out there. There's quite a few in the last year or two. And so I think if we look at what the US has been doing, that may have actually a potential effect on what the Commission may be doing. And just to wrap it up, the Commission may have quite a lot of examples to look, because the US since October 2022 have had a really reactivated look at Section 8. So I think there's a couple of examples that 5 or 6 examples of in which publicly owned companies had to lose some of the board of directors because of Section 8 issues. And the interesting thing I think in here, which is something that may be useful for the Commission, is that in most of the cases, so 3 out of the 4 cases in which this has happened to the US, the type of company was private equity. And so obviously this is something that the Commission also is getting quite, I think quite sensitive. I think they're also looking at it from different perspectives on what private equity firms and the impact, for example, on merger control and other things. So I think looking at it from the perspective of interlocking directorates will make sense. The other 1 or 2 cases, I think it was 3 out of 4 or 3 out of 5, the other 1 or 2 cases were companies in the tech sector, which is also very interesting. And those were, I think it was March 2023, so only a month ago, where a couple of people in the boards of tech companies had to step down because of the US authorities making a claim under Section 8. So I think that's it. As I said in the beginning, more questions than answers from my side, but a little bit of highlights on what's going on in Europe and what can happen in the future is not easy to determine, but certainly we have been to some points. And I now pass the word to, I think, Elias, is that it? Thank you.
I just wanted to start by thanking Matt for his very kind invitation. It's a pleasure to be here and also to speak on this panel, because actually Matt's work has been quite inspirational for me in putting together this working paper, which looks at the role of supply chain resilience for competition law. And the motivation of this paper is the following. So it actually tries to engage with this growing importance that networks of global supply chains play in our day-to-day economies. And global supply chains just describe the fact that we as consumers nowadays, we normally buy quite complex products that are put together by combining different components that are produced at different stages of productions, and these stages of production are dispersed across the globe. So if you were tomorrow to buy a new electric car here in Brussels, it might be that the electric car is then produced in the US or put together in the US, but has, for instance, as a core component, a lithium battery produced in Japan, and the cobalt, which is the raw material for the lithium battery, is, for instance, extracted in the Democratic Republic of Congo. And what we have seen over the last couple of decades is that those global supply chains have grown increasingly efficient. So we had this drive towards more lean and just-in-time supply chains. However, what we have also experienced over the last couple of years, actually, is that we had a number of various exogenous shocks, most importantly, COVID-19, which have actually shown how vulnerable and fragile those supply chains might be. And this then led to calls by policymakers, national level, but also international organizations, who said, okay, we need to rethink how we organize our global supply chains. We need to build back better and enhance supply chain resilience to make those supply chains more robust against shocks and prevent or mitigate disruptions. And what is really interesting from a competition policy perspective is that this building back better philosophy actually had also its inroads into the policy discourse. So you have here examples from the US FTC, but also the European Commission and the UK Competition and Markets Authority, who basically claim that competition law has its role to play in enhancing supply chain resilience. And my paper actually tries to unpack this proposition. It first tries to understand what are actually the economics of supply chain resilience, what is the relationship between competition and supply chain resilience, but also then I try to identify various ways in which supply chain resilience might really be relevant for competition law analysis. And in this presentation, I will just try to give you 3 examples to show a bit this relevance. The first one is when we think about vertical and horizontal contracting, because supply chains basically are just a network of contracts. And in the past, especially during COVID-19, we have actually seen that horizontal contracting and horizontal cooperation might be actually crucial to overcome supply chain disruptions. So therefore, in the UK, but also at the European level and in some other European member states, competition authorities have temporarily suspended the application of competition law to allow for this essential cooperation between firms in critical sectors to overcome imminent supply chain disruptions. But what we also see is that there are other initiatives that try to enhance supply chain resilience through cooperation with a more long-term focus. So you have, for instance, as an example, the Catena X initiative in Germany. So there you have the automotive industry coming together and sharing supply chain information in a database. And this supply chain information also contains risk information and allows thus the automotive industry to predict better supply chain disruption risk. And the Bundeskartellamt, so the German competition authority, has looked at this and so far seems to be fine with the initial stage of this initiative. So you see here that horizontal cooperation rather than competition might sometimes be enhancing supply chain resilience. What is also interesting is if we think about the vertical relationships in supply chains, and there you have recent economic literature, for instance, by Elias and others, which actually suggests that the relationship strength between members in the supply chain really depends on their relationship-specific investment. So if you think about the manufacturer again of an electric vehicle and the producer of a lithium battery, so what is really important for supply chain stability is that they engage in this relationship-specific investments. And if you have excessive entry on one of those levels of the supply chain, it might actually be that those supply chain members no longer can appropriate their relationship-specific investments. And this would suggest that vertical restraints here might actually allow firms to appropriate their relationship-specific investments and prevent free riding, which would undermine the stability of supply chains. So one example also again where actually a more lenient approach from a competition policy might enhance supply chain resilience. Then a second example is multi-sourcing. So think again about this electric vehicle car manufacturer, which is extremely dependent on the steady supply of lithium batteries as a critical input. So of course, if it wants to enhance its supply chain stability or supply stability, it can actually decide to multi-source, so to have actually 2 instead of just 1 providers of this critical input. And if the default risk of those 2 suppliers is negatively correlated, and I think that's an important assumption, then multi-sourcing enhances supply chain resilience. And if we have, in addition, some effective supplier competition, the supplier competition might make multi-sourcing also less expensive. So here we have an example where competition policy, arguably by ensuring that there is some opportunity to multi-source and in tackling bottlenecks, can actually positively contribute to supply chain resilience. The third example that I would like to give you is actually in relation to mergers and industry concentration, the creation of bottlenecks through mergers. And here I just want to give you one very interesting example from the UK. So in 2007, the predecessor of the Competition and Markets Authority, the Competition Commission, cleared a merger between Chimera and Terra Industries, and the merged entity became then CF Industries. And this merger actually was a 4-to-3 merger in the carbon dioxide sector and created a market player with 60% market share. 14 years later, in 2021, the UK experienced a sudden disruption of its carbon dioxide industry and a shortage of carbon dioxide because CF Industries, so this market player with 60% market share, just decided to stop producing any carbon dioxide because energy prices went through the roof and it was no longer profitable for them to do so. And the problem here is that carbon dioxide is really a critical input for the food value chain. So if you think about cooling of food and beverages, if you think about stunning of animals for slaughtering, but also if you think about the bubbles in your water bottle or in your beer, which is really a critical input, I think, then you will see the importance here of carbon dioxide. And what is really fascinating as well about this case is that in reaction to this disruption of the CO2 industry, the UK government then suspended temporarily competition law and allowed the CO2 industry members to cooperate. And my paper actually asks, so could merger control actually account for those systemic supply chain risks and also try to predict, and you see here it's a very long-term time frame of prediction, potential supply chain risks that might arise from a creation of a bottleneck by merger. And if you look at more recent decisional practice of the Commission here in Europe, but also the Competition and Markets Authority, you see that there's a growing concern about supply chain resilience. So the Hyundai Daewoo merger blocked by the Commission, but also the Cargotec Konecranes merger blocked by the Competition and Markets Authority are two examples where the competition authorities also highlight the importance here of having competition in order to ensure the diversification of supply chains and to make sure that there are no critical bottlenecks in the industry. So to conclude, just a few points. First of all, there is a growing awareness for competition, for supply chain resilience and competition policy. This relationship between competition and resilience might be actually ambiguous. And this leads then to a situation where we need to think perhaps or rethink our approach to horizontal and vertical contracting, but also where competition law can play a role in enhancing the opportunities for multi-sourcing, and merger control might be another tool to address supply chain resilient concerns. And I also flesh out in the paper, and we can discuss this later on, potential avenues for competition authorities to account for supply chain resilience. And I also think that there needs to be a further development of decisional filters and also methodological tools. And I think complexity theory can definitely play a role here. So I think there's also a nice link with Thibaut's presentation or keynote. And I will close on this point. And very much looking forward to your questions as well.
So how do I answer?
I gotta say, the slides have been remarkably good at this conference. I've been to many conferences where the slides are like the worst part. These have all been really good. So way to bring your A game, everybody. This is great.
You did the work for him, so well done.
Not me.
Yes, thank you. Yeah. This one, no? Okay, thank you everyone. I'm delighted to be here. Thanks to Matt for organizing this wonderful event and for the invitation. It's always nice to be to this hybrid kind of conferences where you have also practitioners and you hear new things from new people. So I really appreciate it. So I was asked to focus on my work on common ownership. And specifically, I will be talking about today one paper that is co-authored with my economist colleague, Jose Azar, who is a very prominent figure in this common ownership debate. So I'm the legal person in this paper. So what is the motivation of this paper? Someone asked us to write a chapter for a handbook on competition law enforcement and common ownership. And then we thought, okay, common ownership and merger control, but we thought more about the interplay, not so much how you analyze common ownership as an independent matter in terms of merger control, but how taking common ownership into account can influence in very fundamental but also counterintuitive ways, perhaps, merger control policy and enforcement. So that is where we started from. I will try to summarize the paper in one slide. So that is quite a laborious task. And then I have some graphs from the paper. So I will try to expand on some of these ideas to give you some visual understanding of what we're talking really about. And I hope you stay with me. But if you don't, feel free to interrupt and ask me. So I'll try to make it simple as much as I can. It's a little bit of a technical paper. So as I said, we are focusing on the interaction of common ownership with merger control, and we're focusing specifically on two areas. So how the interplay affects policy at one level and how it affects practice, so the enforcement practice, okay? In terms of policy, if you take common ownership into account, we argue in this paper that two basic principles that we have in merger control may change. And you see those principles in guidelines of various regulators in the EU and in the US. So we assume that mergers are generally a good thing, or so to say, we're more lenient towards mergers than cartels, what we heard from Elvira earlier. Okay, and why is that? Because we assume that there is a profitability motive in companies that want to merge, okay, by the shape we have given to the law. Okay, and how we scrutinize mergers. However, if you take common ownership into account, we argue that this assumption is not necessarily valid anymore, okay? Because if you have diversified shareholders that are common owners in different competitors, maybe a merger that is beneficial to those diversified shareholders are not necessarily beneficial also for the merging firms that are involved in that proposed merger. So that, let's say, unsettles established policy quite fundamentally. The second principle that is questionable in this context of common ownership is the merger specificity of efficiencies. Okay, so to what extent any efficiencies put forward by the parties are a specific and direct result of this merger that is being proposed? If companies already internalize externalities before they merge because they're commonly owned, maybe this is also something that is put into question, okay? A second, and perhaps more fundamental, even less concrete, but equally fundamental effect of taking common ownership into account in this merger context is that the welfare analysis of mergers perhaps changes. Why? Because the external effects of mergers, because the profitability motive cannot be assumed anymore, we don't know necessarily what are the effects on the merging parties and on the rivals who could potentially also be commonly owned, okay, by the same diversified shareholders. And why is that problematic? I'll show a graph later by Farrell and Shapiro that they focus and analyze the welfare effects of mergers and merger policy and guidelines focusing on the US, where they suggest that, look, by knowing the external effects of mergers, what are the external effects? The external effects are the effects on consumers or rivals of the merging companies. We can know more or less if the merger is good or bad in the sense that, you know, consumer and competitors' interests are antithetical. Okay, so if the merger is good for competitors, it cannot be good for consumers. So we kind of have a hint from that point of view. In this context, where when you take common ownership into account, that is not necessarily true anymore. So you don't know where you stand, excuse me, in terms of policy. So you don't have this presumptions that hold true in all situations. Okay, so you need more specific analysis. The other thing that is affected is also the set of potential mergers being proposed. Okay, we discussed a little bit in the paper about welfare standards, total versus consumer welfare as a benchmark and a goal to assess mergers. And we say, yeah, there is a big discussion in economic literature, but most jurisdictions choose the consumer welfare standard because they want to induce companies to choose socially beneficial mergers among the set of privately profitable ones, okay? As we tried to show in the paper, under common ownership, as I said, common owners may not always propose mergers that are only beneficial for the merging parties. So the set of mergers that are proposing are a bit dubious in terms of their profitability, at least for those specific companies, okay? And more broadly, that impacts the assessment of both effects. So the point that I made about profitability and also efficiencies of mergers is basically common ownership changes the counterfactual both before and after the merger. Okay, so if there is pre-existing common ownership, that changes the environment, so to say, within which the merger takes place, and we need to take that into account with implications for this assumption that I mentioned. So that is one, the policy level. The second area that is very much impacted and most economic work today is focusing on this is the unilateral effects analysis of mergers, okay? And specifically in this paper, we focus again on the interaction of those unilateral effects from a merger and from common ownership. I mean, the unilateral analysis is very much similar, okay? The metrics and the specifics change a little bit, but conceptually, they were the same thing, so to say. The interesting question is whether when you combine these two different internalization effects from a merger and from common ownership, whether the harm due to the merger is smaller or larger, okay, given this pre-existing common ownership. A more concrete motivation why we did this paper is that there was some literature out there suggesting, look, no, it's a terrible thing if you take common ownership into account in the merger control, because what you will end up doing is create a much more lenient merger policy and enforcement. So they assume that if you have pre-existing common ownership between the merging parties, so the parties already internalize some of those effects, then the merger will have a smaller harm potential, okay? We say, and maybe I think that's the most important finding of our paper, is that this misses a very important fact. The fact that common ownership does not only exist between the merging parties, but the common owners can also have stakes in rival firms, okay? And those can go up and down. And depending then on the whole network of common ownership, you can actually estimate results. So you cannot say in advance that merger policy will be more lenient by taking common ownership into account. As I mentioned, there is some economic literature out there that suggests already some alternative measurement tools of how to take common ownership into account, and that applies also in this merger context. So we talk about modified concentration and pricing pressure indices, so the modified HHI and the modified GUPIs. And we have all the models, I love models and math. And we have also some theoretical discussion for those who hate models and math. So I hope both audiences are happy or can follow somehow. And also we provide some empirical examples, and I'll show some graphs later to highlight how this measurement changes by taking common ownership into account. So what to conclude with regards to the unilateral effects analysis? I think one important finding is that, assessment here cannot be really so much based on presumptions. We need to focus on the concrete facts, so the ownership and governance structure of the companies. But also, as I mentioned, if you take into account the common ownership stakes, not only in the merging firms, but also in rival firms, so the competitors of those merging firms. And in other words, the whole network of common ownership that is existing before the merger, but also how that changes after the merger, okay? You need to know all these facts to actually calculate the precise effects, okay? Of the merger and the interplay of the merger with common ownership, okay? And the other important factor to see if the harm would be larger or smaller compared to the pre-merger situation is the financial structure of the deal, the merger deal, okay? Because it will be a very different situation if the deal is based on cash or stock, and what are the terms of that stock swap agreement, okay? Okay, in the last part of the paper, we also discuss some countervailing factors, such as efficiencies and managerial entrenchment that can counter potential anti-competitive effects. I talked about unilateral effects here. So, as I said, it is a possibility that if we have pre-existing common ownership between the merging parties, that the harm potential of that merger would be smaller, okay? At the same time, the same is true for efficiencies. So this, the merger-specific efficiencies or incremental efficiencies could be smaller for the same reason, okay? At the same time, the same balancing that we do usually within merger control needs to be applied. So that could be one countervailing factor. The second one, which is less familiar to a competition crowd and perhaps more interesting in this context of common ownership, and Thibaut and Anouk mentioned a little bit about the black box view and that we need to look into governance. So managers and managerial agency costs play a role in this story, in this common ownership story. Why? Because whether these common ownership incentives can actually materialize depends very much on the behavior of managers and how much they internalize them. Another way to put it is to say that it will depend on the relative power or influence of those common shareholders compared to other shareholders in the commonly owned companies, and on the discipline that those shareholders specifically can exert towards corporate managers, okay? So in a way, and perhaps counterintuitively, agency costs can be a reason to abide by traditional merger policy, which is a bit weird, but interesting, I think. Okay, to show some slides, I mentioned about welfare analysis of mergers. Our inspiration for this was this Farrell and Shapiro diagram that shows that, socially beneficial mergers are above this 45-degree line, so ABC area mergers. However, companies, so merging parties, will only put forward privately profitable mergers, will be mergers in area B and C. So area A mergers are unprofitable. So unless something happens like compulsions or subsidies, those mergers are not expected to happen. You will not do something as a private company that is not profitable for you. With common ownership, that changes, as I already mentioned. And the bottom line is that that the external effects of the mergers is a bit uncertain. So what happens between the effects on consumers and competitors. And I think the bottom line that is interesting here is that under common ownership, when you have these diversified shareholders that can have a motive to undertake mergers, even though those mergers cannot be or may not be profitable for the specific firms that are merging, that essentially under common ownership, we see more mergers. We see more merger activity for that reason. And at the same time, we cannot assume that efficiencies, at least for the merging companies, are given. A nice way to illustrate the concept behind HHIs, so the concentration metrics that we have to analyze mergers, is to picture them like boxes. Okay, boxes are what? Are like squares. We square market shares to think of, you know, how much of that market a company has. And after the merger, that square becomes bigger. And the difference, so what we call the delta HHI, is basically those two rectangles who is, you can calculate by adding the two sides, the market share of the two companies that are merging, okay? The interesting thing, so by taking into account that change in HHI, you can very much kind of estimate the effects of a merger. What is interesting with common ownership is that, you know, as I mentioned before, the companies may already be internalizing some of those rectangles. So that area is gray, it's not completely white. It's not that it was white and became black. It's somewhere in between, and we don't know exactly how gray it was, okay? And this is why we say it has to be a fact-specific assessment. We also give an example of a merger that took place in real life. So the Northwest Delta merger, that shows this dilution effect that I told you about. For example, Delta was one of the merging parties, and its shareholders gave some shares in exchange of some shares from Northwest. However, what happened for the vast majority of shareholders in Delta is that those shareholders were diluted, okay? So their share in the company became smaller with only one exception, as you can see in this slide, okay? And why is that important? It is important because if you see here, not only the share that those common shareholders had in the merging companies went down, but the share they had in non-merging rivals, so competitors, went up in almost all cases and quite dramatically. And that effect essentially dominated the effects of that merger rather than the common ownership that the companies had in the merging parties, okay? We also show this in terms of the double difference from merger and common ownership by this by using the modified HHI measure, and you see that the common ownership stakes in rivals dominate generally. Also, we take the measures that we have in the US guidelines in terms of absolute concentration. So when you have a highly concentrated market, the post-merger HHI is above 2,500 and the delta is above 200 points. And we compare situations when you take and not take common ownership into account, and you see that more markets are red, so problematic if you take common ownership into account. We did the same thing with guppies, okay, by modifying them. And I think the bottom line here is that, you know, there is a non-zero delta modified guppy even for non-merging rivals. And we show the same thing about the effects of that merger using guppies. My last point is that, you know, the effect on the merging parties is larger, okay? Whereas the effect on rivals is smaller because they're not the parties immediately implicated by the merger. I hope I convinced you. And if not, I'm here and you can interrogate me. So thanks very much.
All right, so we only have a few minutes left, and we can do this a couple of ways. Matt, do you want to share some thoughts, reactions? Do you want the panel to go at each other? How do you?
Yeah, I'm not gonna share. I'll just say this. So what I was gonna share is a project on networks that takes all of the DOJ attorneys and the private lawyers on. I guess it's about 15 years of consent decrees. And it creates a social network. And I mention it literally just in case it's interesting for somebody, particularly young scholars that don't work on this. What this does is it does a couple of things. Instead of thinking about law firms specifically, it allows us to actually visualize, lay eyes on the interconnection between individuals in this regulatory ecosystem, and whether they're on the periphery or whether they're in the center of it. And interestingly, we can also use Social Security data in the United States to estimate the gender of the individuals, and we can also estimate race. And so that we can start thinking about using those criteria, who's at the center, who's at the periphery of the network. And in this data runs from 94 to about 2011. And what you see are things that are unsurprising. Men dominate the network, women are more peripheral. But you can start asking these questions, how does that change over time? And also, what might we do to improve that? And how does that play in the process by which regulatory evolution changes? So that was just a quick thought. I would honestly like to give Elvira the last word. I don't know if there's any reactions you have from practice. Oh,
I can, but I think we'll take the question.
yeah.
I think I haven't addressed today mergers, so I'll definitely want to know if that has anything to do. I think definitely with that kind of a structure. Well, first of all, the first thing to say is yes, I agree with you, and I think that is how I see it. But we don't know, and this is going a little bit back to what Anna was saying. When there is already ownership, then many other things, many other factors, many other elements may escape us, and so that is why it is so, I think, fundamental that when the authorities do look at these things, then we get more transparency as to what may be factors that may escape situations when this is not. I think that's my very high-level elusive question also, because I cannot go into a lot of detail for those companies. Did you want to say something?
I agree. I mean, it will depend on a lot of things, and of course, it will depend how you will assess the what they were, acquiring. Did they have ownership, or did they have contracts, or did they have, directors?
Just in terms of de facto control, so we do not need necessarily a majority of shares.
Yes, but it will depend very much on who is the other
Exactly.
person. If one person has 51%, then the commission will not have a role formally even to do anything.
Well, yes, and so, but to Elias' point as well, obviously, market share is not the only element. So any other, like veto rights or any other things may give control despite the minority shareholding. So that's why I'm saying, so there's all these other kind of things that matter, that give control. So the definition of control, as we all know, in Europe is not centered on the number of shares. So that they could be controlling even with the minority shareholding already, which is why then you will have sole control, and then notified. That's why I say in the particular case, I don't know. But definitely the fact that they got 49% and it was not notified, there could be many reasons.
Usually when we have infrastructure control, we have consistent past evidence involving, records
Yeah.
and things like that. So if there was something and they haven't done it yet, then there is a practical problem also. However, other authorities, just as Elvira was saying, they view all these factors, like the UK authority, they can do them very low thresholds. So they could intervene if they want to. But, yeah,
That's right.
the voluntary
National level.
regime. So
National level is a bit different, but I think just to wrap up the idea, so on market shares, you have to be careful because, minority shareholders can be in control if they are able to, name people of the board or take positions that go directly to the budget prior. So it's the change of control that matters.
I think that is the end of the panel. Thank you, everybody.